Good evening, everyone. My name is Valay, and I welcome you all on behalf of the India Justice Report and the entire community of children's rights friends, advocates, and champions. We are running a little late, so we'll keep it brief. What we will start the evening with is a formal release of the report, for which I would like to invite, firstly, our champion, Justice Lokur, to come onto the stage. Maya, Diksha, Bharti, Geeta, and Anant. Where is he hiding? Yes. Please come onto the stage. Asha, please come onto the stage. All of you cannot fit onto the stage, but so many have contributed to the report in their own way. And this is just a way of acknowledging a few of them. Prabhat sir, please come onto the stage. And some told me flatly that I will not, so don't take my name. So I'm not even going to bother. Please, if you could move that side. So
we did have that choice.
Yeah, and then the team, Nayanika, please, Soumya, Dipul, Bharat, and our indispensable ally, Avinash from How India Lives. Could you please also do this one favor, Avinash, and get onto the stage? And dear Krishna, who's come all the way from Guwahati, who was instrumental in making this report happen. Let's go onto the stage, please. And if you can hand over the copies, please, to Justice Lokur and others. We will all clap once they've opened it. Go, you go. Please. Get a photo taken. No, yeah. Where is from? Justice Loku's already read the report. So. Nayanika, you go right next to Justice Loku, between Maya and Asha, please. Thank you. I'm there. All right, so everybody can get off the stage and take their seats now. I will hand it over to Maya, who will do a introduction overview, and then my colleague Nayanika, who's the lead researcher on the report, will take us through the findings. After that, we will have a panel discussion, very crisp and brief with audience interaction, followed by the keynote address by Justice Lokur. So that's the program. Be patient. Over to you, Maya.
Yeah. There's seats in the front here. Are we waiting for someone?
No, we're not.
Please come.
I think people want to leave.
Well, this is the last chance after this. Please do come to the front. Madam, please. Okay. Good evening, ladies and gentlemen. Thank you so much for being here. I am Maya Daruwala. I work with the India Justice Report, and this is my colleague. She follows me everywhere, so I have to have her here. This is Nayanika. Nayanika is one of the lead researchers on the India Justice Report, as well as for the Juvenile Justice Report. So it's really an honor and a responsibility to stand before you here today as we launch the latest India Justice Report, the Juvenile Justice and Children in Conflict with the Law. I think I have a rival for the speech. Okay. The report is a result of a year-long right to information-driven assessment into whether the elaborate and specialized architecture laid down under the Juvenile Justice Act of 2015 is actually working on the ground, where the children experience it. So does it work over there? Through the available data, it assesses the ability of the system as it stood in the period from the 1st of November 2022 to 2023 to fulfill the institutional arrangements for children in conflict with the law. It is limited to the children in conflict with the law. The other children who are in need of special care and protection, we did not touch. What emerges is similar and familiar and saddening a picture of how far the aspiration and the implementation actually diverge. My colleague Nayanika will elaborate on our findings in much more detail. I will limit myself here to speak about the data dysfunction, because it evidences how the system is actually working. And it is also, I'm not leaving it at that, it is also an area of low-hanging fruit that is ripe for the picking, ripe for immediate repair. Ladies and gentlemen, you all know that the legal framework envisages a specially designed, accessible, child-centric justice system distinct from the adult system, with a robust, with mechanism at the grassroots, and with a robust state and national oversight. Oversight that is only possible when information is available to those who would monitor it, supervise it, and actually also implement it. Those tasked with apprehension, investigation, adjudication, care, representation, oversight, rehabilitation, and integration back of that child into society. That, after all, is the end objective of this whole system. The statutory architecture is absolutely clear and elaborate. Accompanying this is a system of information flow that was also put into place to generate, share, and flow information from first responder on the district upward to the supervisory authorities in the district at state level and up to the center. Yet, nearly a decade after the Juvenile Justice Act, 5 years after the last national audit, and 3 years into digital monitoring, the system still cannot show through routine, collated, public time series data and documentation that it is actually working. And how is it working? Is it working to the optimum in the best interests of the child? Perhaps it is working, but the fact that we don't have enough data to show that it is working leaves us believing it cannot be working. So, our inquiries in this particular instance, many of you have done many studies, and this complements all that has gone forward. But first, we looked at how well are the structures, Juvenile Justice Boards, DLSAs, special police cells, coordination agencies, probation officers, and homes actually capacitated with budgets, infrastructure, human resources to fulfill their mandates. Now you'll find this very, if you're following the IJR, this is the usual way in which we normally look at things. We don't go into much more than looking at the capacity. That's our brand. Second, we looked to see and asked nodal bodies, and we limited ourselves to asking nodal bodies, the Department of Women and Child Development, the State Child Protection Society, Police Headquarters, the State Legal Services Authority, because these are the nodal agencies that are supposed to be supervisors as well as repositories of all information so that they can actually monitor and supervise. So they are the ones who hold data. So how can they fulfill their supervisory and their coordination and monitoring responsibilities? How much data do they have? What did we find? We found that whenever we asked a question, inevitably, these people sent it down to the districts or sent it down to the police station or to the first responder. And what came through to me, and when my colleague and I were looking at it and writing about it, was that there's nobody really minding the store. If nodal agencies did not have the information, then there is no question of regular and routine tracking, monitoring, coordination, supervision, inspection, no finger on the pulse of the system, no unity of purpose among all of the players, let alone any hope of repair and reform. In a way, the lack of information itself was very revealing information about what there was not in place. Sadly, even if its episodic, scattered and fragmented nature, it revealed that there is little to distinguish the system designed especially for children. And it looks really like the larger system that we all know so well for adults. We found instead of setting a higher bar, it bears the same vacancies, infrastructure gaps, impossible workloads, inevitable delays, the same neglected responsibility. So it repeats the patterns and the problems that plague the larger system of adults, and it has the same consequences on the child. So the child, instead of going towards rehabilitation and integration, is going more and more towards institutionalization, from where it may or may not escape. So the same thing that we see. So one of the things we thought when we were writing this was that unlike the adult system, which gets a lot of attention, this doesn't get that much attention, and so it perpetuates. Meanwhile, this little child is growing and growing into something that will not eventually integrate into society, perhaps. I must add here that though we saw a lot of the data missing, to address the continuing institutional fragilities, the National Commission for the Protection of Child Rights has launched a monitoring app called MASI, M-A-S-I, it's a short for something, under Mission Vatsalya. It is meant to be a digitalized platform for basically collecting information about inspections, which is a good start. But it relies on reported data, not on actual evidence of what has been seen. And it is not publicly available. It is a monitoring shell, and it doesn't track remedial action. It doesn't track follow-through. And though it reflects a step towards coordination, it does not have a public eye to it. So this is something that can be repaired. We were talking to Justice Lokur a few days ago, and he reminded us that long ago there was a conversation about when they were starting the NJDG, which all of you know has got all of the information about cases and how the courts work. And a similar thing like that was envisaged for the juvenile justice. And that should be something that doesn't cost money, that technology has advanced, and it could be done, and it could be done immediately. And if it were done, there would be so much more scrutiny, and we would have the chance of doing much better with the juvenile justice system. So accountability and transparency will come from being able to show a steady discipline of showing your work, what has been inspected, what has been found, what has been fixed, and by when. So, ladies and gentlemen, all of you here are practitioners. Many of you have been working for years. Many of you have brought out so much information. I hope that this report, coming from this vantage point, will join the many studies. This study is not only a moan about what is wrong. It is intended to be another flag to those that have the working of the system under them, and to assist them, along with all of us, to work so that the promise of this system, which is a child that is treated with dignity and has a second chance coming out of that system. And I hope that this report will go some small way from this room and out into the open to make that happen. Thank you.
Good evening, everyone. I am Nayanika. I will be quickly taking you through just a few of the findings of the report, a few important findings. Do want to tell you that please go through, whenever you have the time, do go through the report, because we have district annexures, we've got the raw data, and if you would like more data, we would be very happy to share them with you. Moving on, I would just like to quickly show you one of the main findings, which is, I'm so sorry. Can someone, yeah.
You see, this is what happens when I'm not standing with you.
Try not to move that, yeah, okay. But I can present full screen, right? Yeah, okay. Right. Right. As Maya also, as Maya just mentioned, that we filed to around 20 all the states and 2 union territories, Delhi and Jammu and Kashmir. We found that mostly institutions that should be available are available. For example, in the the presence of juvenile justice boards in the 765 districts that we covered. We found that there were only about 92% coverage, or about 707 JJBs. The 11 states on the right hand side are the ones that show that all districts don't have a JJB. For example, in Rajasthan, which has about 41 districts, it has only 34 JJBs, and 7 JJBs are yet to have JJB. This could also be because new districts have been created, or have been merged. That's why they don't have a JJB yet. But more importantly, what we did find was that while states report that all principal magistrates were in place, more importantly and more concerningly, social workers' positions were the ones that were missing. Now, we all know that JJBs were envisaged to be a multidisciplinary body, but 24% reported that they functioned without a full bench. For example, Delhi here on the left-hand side, you'll see that Delhi has about 7 JJBs in its 11 districts, so it should have had 14 social workers, but it has only 7. Only 13 states, I think, reported less than 10% vacancies, and just 3 states, Jammu and Kashmir, Odisha, and Sikkim, reported that all JJBs were properly constituted. In a first-time exercise, we tried to... I'm sorry, am I going too fast? Oh, okay, great. So I'll go faster then. Okay, so... Right. In a first-time exercise, we also tried to capture comprehensively what a JJB workload looks like. Like Maya also mentioned, data is scattered, data is not, captured centrally. What we found, again, because the data was RTI-based, not all responded to us. Not all 707 JJBs responded to us. Only about 362 JJBs responded to us. And we find that in those 362 JJBs, they had a caseload of more than 1 lakh, and they disposed of just less than half, which is about 45% or so, and more than 55,000 cases remained pending. Again, I want to note here, and also want to remind you that we have individual JJB data as well. And if you'd like, you can go through our report. It's in the annexures, and you'll find that a JJB in Indore had about a caseload of 2,200. Murshidabad in West Bengal had about a pendency of 1,400 and more. So, and you've also got JJBs which cleared all cases, but had a workload of 2, something of that sort, which is great. Yeah. Pendency rates obviously go... Odisha reported the most pendency rate. It disposed of just 17% in the year of our assessment, which is 22-23. So 83% cases remain pending in Odisha. Now, legal aid services, again, something that we know exists on paper, and we've got a lot of expert practitioners here who I'm sure can dive more deeper into the quality of legal aid. But what we found that, again, you can see 707 JJBs or 705 JJBs, only 437 responded to us. I'm sorry, is this not not visible to you guys? No? Okay, I'm sorry. So for this side of the audience. So 437 JJBs responded to us out of a 707, and they told us that there were about 305 clinics only. Now, 6 states here on the screen show that there was 100% coverage of clinics, which means that every JJB had a clinic attached to it. But again, we don't know what the quality of that legal aid is. How many times does the JJB sit? How many times do the lawyers come to the JJB, etc. On the other hand, on the spectrum, you'll see that Manipur and Nagaland reported here, the empty ones, reported that there were no clinics. Now, as you know, probation officer is one of the most important duty holders in the JJ system. He or she is the one who actually takes the child from the moment that the child enters the system till the child leaves the system. On our query to states to understand how many LCPOs there were, for those who don't know, a probation officer comes from 2 streams. Basically, one officer is appointed under the Probation of Offenders Act, and the LCPO, which is the Legal Cum Probation Officer, he is appointed under the Mission Vatsalya. Now, Mission Vatsalya envisaged LCPOs to be a dedicated cadre, which we find in our study that it's really not, because we've received responses from only about 14 states, which is about 236. So there should have been 236, but there were just 197. And if we were to calculate very conservatively, approximately what their workload is like, we took the total workload, which is the total workload available to the JJB, to understand what could because there are other people who also, like a social worker and a case welfare officer, who also work as a probation officer in case they are not available. But we found that of the 25,000 cases with the JJBs in 10 states that provided us both data, one LCPO had on average had to deal with 175 cases. For those people there, Delhi reported about, Delhi has just 3 LCPOs in its 11 districts, which means one LCPO approximately has to deal with about 800 cases. Now, 800 cases means probably more children. So 800 children, yeah, it's a massive workload. Right. Now, while most of our data was RTI-based, because data on states, on their childcare institutions and the number of staff in these institutes was very, very uneven, very patchy. Not all states responded to us. We relied to a Lok Sabha parliamentary question, which told us that there were about 400 different kinds of homes for children in conflict with law. Now, of the states that did respond to us on staff, we have, again, very patchy data. About 80% said that they had no medical officers. About 45% had no counselors. So on top of that, there were only about 16 states that said that, yes, they have a place of safety, which again, as we know, is a very important home for 16 to 18 years of children. So 14 states said that they had no homes. Now, this is basically like a teaser of findings. Please, I would request you to go through the report if you can. Because what we could find, just to give you an indication, that we reached out to 765 districts, but we found usable, sufficient data from 292, which more or less met the 7 points that we had tried to cover, that we had tried to assess. And only 11, and 8 of them were in Mizoram, met more or less all the 7 points. Here I'm still saying more or less. It's because Mizoram, for example, reported that there were no doctors. And one out of these 11 districts reported that there was no counselor. So even in the 11 states, which gave us a good picture of what could be happening, which could be a good indication of what is happening in the rest of the country, it gave us a good indication, like a good picture of the state of the juvenile justice system. Also referring to what Maya said, that data is not being shared. So that's it from my end. I would now request Vale to come and take over. Thank you.
Can you request them to put chairs back on the stage, please? Yeah. Meanwhile, I wonder how many of you were able to see the budget pilot study that we have put outside. IJR has started this project of compiling all the state budget documents relevant to the justice sector and culling out information related to law and justice and Ministry of Department of Home Affairs, as well as WCD and so on. The idea is to start creating a baseline of budgets for justice, which currently doesn't exist. Like what we have had so far is analysis of the central schemes largely, but we want to do this at the state level. And so I would just request you to pick up that copy and also look for it on our website. And in the future, maybe some of us can collaborate. Right. Thank you. So now, to have this panel discussion, just want to invite Deeksha Gujral, the head of iPro Bono, onto the stage, as well as Miss Geeta Sajan Shetty, who's traveled from Kalaburgi. She's a JJB member there. She's an advocate. She used to work with the Center for Child and the Law at NLS Bangalore, and Bharti Ali. The idea is that in this about an hour, we will have one round from the panelists, then we will open it to the floor and take quick responses, reflections, and make this interactive and enriching for everyone. So, let me just begin by saying that we have seen all this data, uniquely granular with limitations, but uniquely large about the importance of regular publicly available data, as Maya has also mentioned. Of course, the panelists here represent a wide diversity of experience, expertise, as well as, in a way, region. But the hall itself, if I may say, is equally, if not more diverse, has more expertise and experience, both on the policy side as well as on the other side. So, with that little bit of context, I would just like to ask Bharti first. We talk about, in our rhetorical speeches, we always mention the demographic dividend. And we've always, at least I'm sure people in the room believe children are a great unifier. They are also apolitical. The children's issues are considered apolitical in that sense. And yet, we see that the system has let children down, has abandoned them in a big way. But Bharti, I want to ask you, in your experience, what actually helps in bringing systemic change and what helps in sustaining it?
Well, we've, all of us here, I think many of us here have been working with children in conflict with law and for children in conflict with law in different ways. Directly as well as indirectly through advocacy, research, investing in creating evidence as you have done. The problem lies in the fact that none of this evidence is collected consistently, as I think Maya also pointed out. I recall that in 2019, NALSA had done a similar study looking at structures and systems and mechanisms in the JJ system. I do see some difference in the findings, but that's probably because NALSA, with its access, could get a little more information than what you could through RTI. But after 2019, this is the only other attempt I see. In between, we have the juvenile justice committees now from various high courts, and annually they meet. But again, there is no systematic effort to collect data and to monitor. Through interventions from the Supreme Court, there have been attempts, but I think after Sampurna Behura, we again lost track of what was happening with this within the system. So that consistency is very, very important in terms of generating evidence from the ground. It's even more important because we've always said that children in conflict with law, we can't share information, we need to maintain privacy and confidentiality. So in the name of maintaining privacy and confidentiality, we've actually kept the whole country away from a lot of data and insights that are necessary to ensure transparency and accountability. So I think we need to start talking about bringing that transparency and accountability. The other efforts which continue, and I'm so grateful to every lawyer in this country who's representing a child in conflict with law today, because without that we probably couldn't have done justice to juvenile justice. So we need more lawyers. We need to create a cadre of lawyers who will continue to do this and identify issues that can be taken up as strategic litigation and taken forward. There are other experiments which different organizations have been doing, but I think we first need to correct what the law is asking us to do. And if in these many years we haven't been able to implement the law, we can't be again changing it for some other case that goes wrong. That's what happened in 2015, right? Or it was made out to go wrong. So that's what I have to say for now. I was looking at some of the findings, and it's very interesting that Orissa has more JJBs than the number of districts. And JJBs are also properly constituted as per the report, but the disposal is only 17%. So we need more in-depth analysis. We need to probably pick out these kind of findings and go down to the ground to see what's really happening.
Thanks for giving me that segue to, I will come to Deeksha, who can probably talk about the more granular findings. But Deeksha, just right now I wanted to first go to Geeta, and because she's been on the other side for several years, and now as a JJB member, if you could speak from your experience, how much of this data reflects reality that you are seeing for the last 6 years as a JJB member?
First of all, what Bharti pointed out just now, that in Orissa there were more number of JJBs than the districts. Even Karnataka, as per their finding, even Karnataka has more number of districts, more number of JJBs than the districts. I'll tell you why. Because the pendency rates, when it increases, we have had additional, like Bangalore has rural and urban JJB, even Kalburgi has rural and urban JJBs. So therefore we have places where pendency is very high, and therefore the number of JJBs have increased. And the pendency is quite high despite the JJBs being higher in number. Why? Because there are systemic issues that is taking place. When juvenile is apprehended in Kalburgi, I was there for past 6 years as JJB member. Not even once, the child was produced before a JJB member. It was systemic that every policeman, whoever apprehends SJPU or the child welfare police officer, has to produce it before because they consider only judge as the judge of the JJB. So the social work members, though they are there, they are considered only as a decorative piece and rather a rubber stamp than being considered the actual member. And when we try to correct it, we are seen as, oh, she thinks too much about herself. So this is the way how the system responds. So, and this thing continues, the pendency also continues because FIR is being filed even in petty offences, serious offences, though there is a bar in the law. And when this is pointed out, they say, madam, already cognizance has been taken by the magistrate, so now you can't do anything, we will have to go on with the case. And once the case is there and charge sheet is filed at a very delayed stage, because it's if there is only child in the offense, then charge sheet is filed as per their whims and fancies, because child has been given bail and is no more in the OH. So what is your problem? They'll file at their own convenience. So this is also giving rise to pendencies. So there are several factors which are systemic issues, and that needs to be identified and that needs to be brought out before the JJ committee, Supreme Court. Though these issues have been spoken out at the local JJ consultation in Karnataka, But I'm very sorry to say, even if it is a High Court committee, after the consultation is over, the recommendations made in the consultations are not given importance and there is no follow-up.
Just a quick follow-up, that the Section 16 of the Act already allows for monitoring by the CJM and the CMM. In your experience, how much of that actually happens?
Yes, there is a delay to get, see, in order to get an additional JJB, we had to follow it up for 1 year, and in the meanwhile, when the permission was got to get one more additional JJB, the pendency reduced. This is very, very, and it all depends also because the judges change. So a judge who comes, who wants quick disposals, some judges, they just don't come to the JJB and there's no one who can question them. Why nobody questions them? Because the social work members are usually advocates, and advocates don't want to challenge the JJB chairperson because it will come in their professional understanding. Tomorrow that judge may come to High Court or may become district judge, and you may be appearing and you have challenged them, then it would affect your case before him. So these are the nuances, and Bharti has been advocating that JJB should not have advocates on record because the body is envisaged to have multidisciplinary personals, but still we end up having only advocates, and therefore cases are being looked at only from the angle of legalistic angle, whether there is evidence, no evidence, and then case is closed. No one is looking into the aspect of socio-psycho-economic impact on the child. What has been his circumstances? How do we rehabilitate him? This aspect nobody is looking at.
Yeah.
So this is a systemic issue that needs to be really addressed.
I think Bharti wants to quickly add something.
Just to let everyone know, in Delhi there was a high-level committee constituted under Section 16(2) of the JJ Act, which is supposed to be looking at pendency and reviewing pendency. This was in 2016, and we met for the first time last week or the week before.
Yeah,
So
and that's a great toss-up to Diksha, when I Pro Bono does multi-approach work, and I think you were referring to the latest research. Could you talk about that?
Hi. Yeah, so what I basically wanted to focus on is the need to have data that is, I mean, the study is impressive for the breadth of the data that you're able to collect at a national level, but the depth of the data as well, informed by the local circumstances, which also tells you what is the data points you need to collect on. That I think is really pivotal, and what I'm hoping is that this data that you've collected will allow people at the ground level in different jurisdictions to engage in that kind of research, to engage in that kind of intervention, because this opens the door to use data in an interesting way. The example that I was sharing with Valay recently is that we did at I Pro Bono India, we did a huge amount of data research on what are the issues plaguing the juvenile justice system in Delhi, and we looked into pendency, broken down by cases that are of different nature, so heinous, serious, petty. We looked at what are the monitoring mechanisms in place, and we looked at what is the availability of that data publicly. And it was interesting because what we found was, despite an order a couple of years ago closing all petty cases in a different case, once again we reached a point where something like 206 petty offence cases are going on for longer than 6 months, and there are cases that are going on for longer than 3 or 5 years for petty offences, which is ludicrous. Over and above that, you have close to 1,000 cases of serious offences, over 1,200 cases of heinous offences that are going on for longer than 6 months, with no application of mind about what are the consequences of that. If we look at the juvenile justice system, what are the consequences of pendency? You're looking at a long-term impact on the rehabilitation of the child, which is the ultimate goal of the Juvenile Justice Act. So pendency is not an issue in itself. Pendency is an issue in terms of what happens to the child going forward. When you have we have cases where we represent children who are in their mid-20s. Well, children is a strong word. Young men, young women who are in their 20s, who have jobs, who have lives, who have, marriages, and they're still carrying that burden of the case that happened when they were 15, 14, 12 years old. It basically undoes the entire purpose of the Juvenile Justice Act. So we took this data regarding pendency, we took the data regarding the lack of oversight, the high-level committee that Bharti was talking about a moment ago, the fact that there is no oversight by any other body as well, and we filed a writ before the Delhi High Court. And it was actually really wonderful for us to see how quickly that moved forward. It was referred to the Juvenile Justice Committee. The Juvenile Justice Committee has already directed that a lot of that data be made available on as part of the National Judicial Data Grid. The JJB data will now be made available, which is a big step forward. Justice Lokur mentioned as well that having that data in the public sphere allows for a level of accountability that otherwise doesn't exist. So we're hoping that will happen soon. The high-level committee has already met, which is wonderful.
One state.
Well, we filed in Delhi, so it's met in Delhi. We're counting that as a win, as a starting point at the end of the day. Also, very often the things that start in Delhi can then be implemented as a best practice elsewhere, which we hope will happen. And we've recently been told that the district magistrate has also been asked to do an evaluation, which is also something that we had asked for as per Rule 12(2)A of the Juvenile Justice Rules. So it's fantastic when you can take data that is localized and points to specific issues, make those very specific asks, and then be able to achieve some kind of conceivable result. What we hope for now is that actually moves forward and has impact on the ground, because ultimately what we're looking for in a juvenile justice system is one where the pendency is minimal and the rehabilitation and the rate of recidivism, well, rehabilitation is at its highest and the rate of recidivism is at its possible lowest. And everything we're measuring at the end of the day is to try and achieve those goals. So the goal is to try and achieve that and put the systems in place to make that happen. How long that will take and how many of these efforts that will take remains to be seen.
No, I think on behalf of IJR, take the point about localizing and making the research deeper. But we believe that we should start with a national SITREP, a situation report after 10 years of the new act and where things are. And we thought that this was important for it to be a conversation starter, a point of takeoff for further research and action. I'll stop here, and I'm looking at the audience. This is our time to weigh in. There doesn't have to be questions. It can be reflections. And I request my colleagues to just be there ready with the mics. Whoever wants to go first. To the panel or a reflection. Yeah. Maybe can you Sure, yeah, I think so. We can hear you.
My reflection is from where DJ has said that there is a very delayed and long process. Considering a normal Indian criminal justice system is a very long during process. After introducing my reflection on what we are saying in cases only, 10 years it's going to be 2015 amendment, and still the district children's court does not know that they are district children's court, and then they don't know there is a 19 procedure. After a preliminary assessment, children's court has to do a separate assessment, and still today a bail order was decided in a JJB in Delhi, where a replay of the police officer is still a regular replay, not being section 12 replay of JJAC. So what I'm trying to say is the JJB are also deciding the case on the facts and circumstances of the case, bail applications are decided. So what I'm trying to ask is 10 years is not enough to give awareness about that. Still after 10 years, not I am speaking about the lawyers or the civil society, I am saying about the people who are the stakeholders. A children's court doesn't know there is a section 19 procedure. After considering as an adult, they directly going for framing of charges. A juvenile justice magistrate doesn't know that the bail has to be decided as per section 12. Not speaking about 5 years back, I am speaking about an order today passed. police officer is again and again giving 483 ka bail replay than being section 12 ka replay.
Yeah.
So I'm just asking, the stakeholders are not given awareness even after 10 years of that. So how long does it have to be go? And what needs to be done?
Thank you. Very important point. I think. Can you just introduce yourself, please?
This is Rahul. I'm an advocate working with iPro Bono India.
Okay. Asha in the second row.
Well, I have a few things that I've written down.
We have 2 minutes. Yeah.
So when we are talking a lot about how this whole system is, there's a lot of influx of, the understanding is that since it's children in conflict with law, we require a lot of lawyers in the system. And I think we need to reconsider or rethink about this process because, Geeta ma'am rightly said that if you look at the JJB, the principal magistrate is a person from the law, plus the 2 social workers, invariably in every district, are people from the law background. Then we have the child being represented by the lawyer, then we have all lawyers within the system. There are no probation officers, there are no social workers. So when we are talking of rehabilitation, where is a person who can actually rehabilitate the child? Because it's all about the case and it's all about lawyers now. So when we are calling this a socio-legal system, I think the socio is completely lost in our system, and right now it's a completely legal system. So we have to look at it. In Maharashtra, we kind of pushed it, and in 2018 rules, we bought it, we couldn't remove lawyers completely, but we said in the among the 2 social work members, both of them cannot have the same educational qualification. So in that sense, we kind of put it, but still, they keep doing things, though it's there in the rules. If you look at, again, children in conflict with law, there are 2 categories, one institutionalized and non-institutionalized. Almost 80% of children are non-institutionalized. There are hardly 20% of children who go into the observation homes. Observation homes have, staff, so we say permanent staff, but the entire JJ system is working on contractual staff. The system is contractual now, and I don't think we can even talk about child protection with contractual staff. Again, this is a failure, this is a big failure in the system, and we are talking about increasing effectiveness, but no, we have lost things. It's almost like Mission Vatsalya is running the JJ Act rather than the JJ Act running Mission Vatsalya. It's that kind of a system that has come into picture. Regarding data, I think, I don't know whether Maharashtra has shared data or something, but since we work in Maharashtra, we know that there are many districts in Maharashtra where the pendency is more than 3,000, 4,000, right? And one last thing before I conclude, this whole demarcation of petty offense, serious offense and heinous offense, I have a major issue with it, because when we work in the system, our understanding is people who commit heinous offense are a very small, minuscule population among the total number of children who come into the system. And that out of that who commit heinous offense, most of them are circumstances have driven them to commit that offense, and they will never get back into the system. It happened out of a one-time thing. But we give so much of importance to that heinous, and we keep saying petty, 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 and we leave the petty out, but we are more concerned of the petty, because it's this petty that we are just letting them go and not talking about rehabilitation. And I think that is the most heinous offense, and I think we should work more with the petty rather than the heinous, but it's all being misunderstood in the whole process.
So last one from Krishna, and then we'll come back to the panel, and maybe Sachi in the front row, quick.
Hi everyone, my name is Krishna Sharma. I've been part of this study as a consultant. Thank you for IJR to taking part of this. But one of the reflections that I would like to make now, working with another organizations and in a different state, this is a very deep reflection on what I have learned in last 5-6 years in child protection. Is Delhi is not the right place to judge the entire system that is working in entire India, because what happens in Delhi is still the best, I will call. then when you go deep down to the other states, we will find that how the system is actually working. So my first reflection is that we go out of Delhi and try to see system beyond that actually happening. Because even in this study, we have responsibly put it out wherever we are lacking. But once you go to the other states, you may find there are some findings which may not have recorded, and that has been responsibility been mentioned that why it is because of the data. And another thing that I would like to point out that we are talking about rehabilitation. Obviously, we are only looking at the stakeholders and their responsibility. But if we go deep down to the rehabilitation system in actual, we will say that we are lagging a lot behind in that as well. So if we have tried to cover what are the rehabilitation that have been provided in different states. So the point is that we as an experts, not only as lawyers are important, because me being lawyer, I personally would have a say that lawyers are important in the system, but I do feel that every important stakeholder, be it social worker, prohibition officers, and even the superintendents, the people who are working with the children in the home, all are equally important, and we need to sensitize each one of them. So that's my thought. Thank you.
Just hand it to Sachi, please, and then we'll come.
Hi, Valay. So just couple of things from our experience in Chhattisgarh, Jharkhand and Mumbai. One is that most in Chhattisgarh, Jharkhand especially, what we observed is that position of the councillor was mostly occupied by a social worker. And so the appointed person is a social worker. The other thing was that under Mission Vatsalya, many new facilities were created in places where there were already existing facilities, like a special home, children's home, and there is no prescription on what these facilities should look like. So if you go to Chhattisgarh, the facilities have windows which are on the top. You know, the room has cement beds. So these kind of things which really need to be looked at. Apart from that, in Jharkhand, because there is no place of safety or very few places of safety, at 18 children are directly transferred to the prison, whether their cases are going on or not. So these are some things. Also, in the report you mentioned about the girls' home. We went to many girls' home in Chhattisgarh, where an entire bungalow sort of a space was there, like the same as boys' home, but there were only 2 girls in it, and that itself can be very scary for children. So I think we need to also contextualize and think about what kind of homes for 2 or 5 or 10 children in conflict with law girls should be there. So that's another thing. I think also the cases in the Sessions Court, which have started right when the Act was enforced and then still continue in the Sessions Court, a lot of times, at least again in Chhattisgarh and Jharkhand, the moment they see POCSO, they see 376, 302 IPC, immediately the cases are transferred to the Sessions Court even without a single hearing. So some of these things also need to come out, because the Sessions Court piece feels like, you know, there is more problem than the JJB. Thank you.
I mean, you guys can go, but I just want to say to Asha that when we try to disaggregate budgets for CNCP, children in need of care and protection, and children in conflict with the law, that disaggregation is missing in budget documents. So how do we even begin to argue that 0.03 is entire child protection? So it's a long-standing issue. Huck has been doing it for years and so on. I just wanted to say that. I think Bharti wanted to respond.
Since we're talking budgets.
But just the questions were awareness, then Asha's point on probation and so on. I think Krishna's point is addressed by Sachi, who's talking about Chhattisgarh and Jharkhand, so we can thank you. It's a very important point, Krishna.
Yeah. So, I mean, the reflection, a reflection of how much and how keenly we want to invest in JJ comes from the fact that we combined a lawyer's position with the probation officer's position to call them legal cum probation officer. We wanted to save on resources. And then when it came to having 2 social workers in the special juvenile police units, the ministry said we'll get the social workers from the DCPU. As if the DCPU social workers do not have enough of their own tasks to do. So that's how we've treated child protection issues, and particularly Juvenile Justice Act. The law will not, the law needs backup financial backup in the form of some scheme. And whether we like it or not, we have Mission Vatsalya. But even with Mission Vatsalya, there has been little engagement of late. And there's been little consultation as well. So I think that space again needs to open up if we truly want to, start looking at how the system is functioning and where are the gaps and loopholes. Indeed, part-time salaries, contractual workers is a huge, huge, huge problem. But more than that, there are vacancies lying. In Delhi, I know Anant is here, there was so much struggle trying to get the department to do a cadre review. Because if you are talking about child protection cadre in a particular department, what should that cadre look like? And does Mission Vatsalya really cater to that need? And that kind of an exercise, I think, is required across all states. Of course, it's been a huge struggle in Delhi to get the department to make that first step. I don't know how long and how many more years it will take to actually get that document in hand called cadre review. But those are steps that are definitely required. There were some other thoughts that were coming to my mind, when we talk about individual care plans. Something which we said 10 years ago when the Nirbhaya thing happened, we said this child has to have an individual care plan. We continue to struggle with that individual care plan even today. And if we don't take it up on a mission mode, I don't think any child will ever have an individual care plan. The petty offense cases, the beauty of the JJ Act is in the fact that the principles of bail are very different, right? So if there is a child who is booked for a petty offense and requires additional intervention, I think the Act allows you to make those kind of interventions, even if that means keeping the child in an institution for a little longer to support a rehabilitative measure. But we don't understand that. And it's not that Delhi is a very rosy picture. Unfortunately, that's not the case. And over the years, what has happened is that even after a lot of investment in training, every judicial academy in the country today invests in training of JJBs and CWCs. The National Legal Services Authority, Delhi State Legal Services Authority, all state legal services authorities invest in capacity building and training. But despite training, today what we are seeing is magistrates who just don't want to budge from the criminal justice practices and procedures. So I think it's not about giving training on technical skills and knowledge. I think now we need to start thinking about sensitizing, bringing an attitudinal change. The problem today is that attitudinal change.
Some of us continuously work on training. But
Yeah.
I wanted to ask Diksha or Geeta if you want to.
Sure.
Yeah.
First to just address the point on the over legalization of the system, which I think it's a fair point, because at the end of the day, if we're looking at long-term rehabilitation, there is the role of everybody outside of the lawyer, and it also creates an undue burden on the legal system and the lawyers if you're expected to perform that role. So the role of a legal cum probation officer is supposed to be this. It's supposed to be to go beyond and to be able to prepare ICPs, to do all of these things. In UP, they're acting as stenographers. In Delhi, they're sitting in JJBs, there's 3 of them, and they're being asked to do administrative tasks. So-and-so child has come for their hearing and their grandmother's sari is torn, please go help. So-and-so child has come, their shoes don't fit, what a travesty, take them outside. And there is no logic allowing these people to be able to do the role that they are envisaged to do.
Protocol duties, go pick up Bharti Ali from the airport.
Exactly.
That's the probation officer.
And that's when they're lucky, because then you also have the fact that you've got no safety mechanisms in place for these people. We've heard stories of probation officers who were told, please go to XYZ place and prepare an ICP for this child. You arrive at a basti where this child is involved in gang violence. You're taken to the person who is allegedly the parent or guardian of the child. 45 minutes later, you find out this is actually the gang leader. This is not the parent. This is not... So this person is placed in extreme unsafety, and then obviously is next time really wary of putting themselves in that position, because as someone said to us recently, I have a wife and children. What's going to happen to me? We've had an instance in the past, it's been reported, where there was a probation officer, an LCPO, who was beaten up in the place of safety. Now, if you're looking at a reality where the system is not able to protect the stakeholders who are meant to be a part of that system, how can we expect rehabilitation as an outcome of this? So some sort of systemic review of what is the lived experience of each of the stakeholders is important. We are talking about a system where allegedly in a whole group of states there are enough principal magistrates at the very least. How many of them are full-time? How many of them are doing this as part of their role? In Ghaziabad, you have a principal magistrate who's only able to sit for 2 hours in the afternoon on some days. We cannot say that's a properly constituted board. Technically, there may be somebody appointed to that position, but if at the end of the day, you're not able to perform your role because of limitations beyond your control or a lack of sensitivity, as the case may be, we cannot expect that system to work. And so we should not be surprised when there is no rehabilitation happening. We cannot be surprised when children are re-entering the system over and over again. We can't be surprised when we find out there's children in homes for months upon months for offences where they would have been released if they'd known who their lawyer was, but they don't know that because there's nobody there who is in touch with them. So I think at a fundamental perspective, we need to look at it not just institutionally, but we need to look at it as what is the lived reality of each stakeholder, and how do we make that a part of our problem-solving technique.
So do you want to comment? Yeah.
Regarding individual care plans, despite there being a law which says that every dispositional order should have an individual care plan, in fact, when we requested the magistrate, let us get the individual care plan, his reply was, Madam, we have points for disposal of the case. If I get an individual care plan and start looking after implementation of that, my points would be gone. We won't consider this case as closed. So consider my position. So this is the judge's reality. Yeah.
Yeah, I'll just request new members to raise their hands, but before that I want to just do quick follow-ups. One is drawing from the study, where I want to understand if there are no observation homes, are children more likely to end up in adult jails, especially to Diksha? And then if Geeta is disagreeing, but is that your experience? Is that the study that you...
I mean, there's any number of reasons why children end up in adult jails. I don't want to say that this is specifically the main reason or the only reason, but it's certainly a contributing factor. I mean, the fact that you have states where, including UP, where you have standing orders, if a child turns 18 years old, they will be transferred to the adult jail. But what's interesting is that I think the lack of a sufficient number of childcare institutions is the reason why parents are very often accepting children being transferred to an adult jail. It's one of the reasons why people tell us, if my options are that my child is in a place of safety so far away that I don't know when I'll see them next, versus the jail where I can visit, that is a preferable option. That is certainly impacted by the availability of homes. So, when we say we want to meet the standards expected by the Juvenile Justice Act, I think sometimes the standards are not high enough. To say one place of safety per state and you've got states the size of UP and MP, that's not a realistic expectation, nor is it able to be conducive towards long-term rehabilitation. Yeah. But there are, again, this data itself is indicating why there are so many reasons that children end up in jails, the lack of sensitivity being key among them.
Yeah. In fact, MP Indore's JJB has the highest number of, the largest pendency in our data set. Mm-hmm. So you were mentioning MP, I thought I'll just mention that. Geeta, if you want to quickly disagree.
I just wanted to say that whenever there are no OH observation homes in the district, they are sent to the next district which has got the observation home, and then they are produced before the JJB. So that's the one practice that Karnataka had been doing, and why children end up going to jail is not because of there are no OH, it is because of wrong recording of the age. Though the child mentions I am minor, I am below 18, still there is an adult offender along with the child. Most of the heinous cases, there is always an adult offender, and they record his age as above 18 and they send him to jail. Then he files an application to be transferred because he's a minor. Once he comes here, then the JJB decides it's a heinous offense. Then they again send him to children's court. And just it's a revolving door that the child is going through, and we are looking only from the perspective of the child. Now, if you look at the victim, if there is a child victim, we can only imagine what is the status of the child victim.
Can I just add, some experience from Jharkhand where we figured out that one of the reasons for pendency was because, the observation home was very far and parents and children couldn't afford to travel all the way for a hearing. So the hearings would just defer endlessly. And those are realities of people. Where do they get the travel money from?
Yeah, absolutely. I mean, these are the most marginalized segment of our population. I think Sunil, we'll go back to the audience. Sunil wants to intervene from Bihar. If you could introduce also quickly.
Thank you, Valeji. I'm Sunil and I'm based in Bihar, working for the past now 15-18 years. मुझे कुछ यहाँ पे 2-3 पॉइंट्स रखने हैं, ज़्यादा वक्त नहीं लूँगा. इंडिविजुअल केयर प्लान पे आपने कहा, तो we can make a very good individual care plan. It's quite detailed. Now in the amended rule of 2022 model rules, we have yet got another एक बहुत ही structured individual care plan बन गया. But even if a probation officer recommends that the child needs mental health support, the child needs vocational training support, or the child needs higher education support, where are the services? Will that individual care plan be ever executed? No. So the case worker or the probation officer, even if he or she wants that individual care plan to be one of the best, which serves the rehabilitative ends of a child, it is not going to be executed. So that's why you will find most of the individual care plans just blank and with few recommendations which become just something to be complied with. That was for the individual care plan. So far as CCIs are concerned, since I have worked very closely with the institutions and the system, what I have found is that although the Act talks about different categories of childcare institutions, so when they are talking about different categories of childcare institutions, children's home, then special home, place of safety, observation home, but then the scheme, the Mission Vatsalya scheme or its erstwhile scheme ICPS, when it presents the budget, the staffing structure, the processes, it just mixes up everything. So there are different homes, different institutions which have been designated for different purposes. Where are the process? Where is the different workforce? So that one. The third thing, last, with JJB data, I just inquired about what is the pendency of cases before JJB in Bihar and in Uttar Pradesh. You will be surprised to know that in Uttar Pradesh, as on October 1st, there were more than 33,000 cases pending, and in Bihar there were 43,252 cases pending. So your report shows
it's the tip of the iceberg, what our report shows. Yes.
Tip of the iceberg. So just 2 states combined together count more than 75,000 cases pending before the JJB.
No, thank you. I think Ranu, please, over there with the blue pen. And then Nimisha, but I would now become a little more strict because we have to close at 7:45 as Justice Lokur has to be elsewhere. and he's been waiting very patiently. Yeah, okay. Maya is right behind you.
So I had some reflections on yeah, sure. So I'm Ranu. I'm a legal research associate at Enfold, and I was asked to speak about something on rehabilitation and reflections on it. So I had some 3-4 points regarding this. So firstly, I think amongst the stakeholders especially, there's a need for holistic understanding of rehabilitation. It cannot be limited from what we have seen in our needs assessment reports and talking to different stakeholders. The understanding is limited to access to education and vocational training. But rehabilitation must encompass physical and mental health well-being, attempts towards social reintegration, etc. So maybe like a cross analysis of how these measures impact education or vocational training can be a step forward. Related to this, I think, is also the attitudinal shift that is required in how CCL are perceived by the stakeholders. When it comes to children in need of care and protection, there is still like more understanding of their overall rehabilitation, holistic rehabilitation. But for children in conflict with law, there is somewhere stigma, discrimination that is inherent in the stakeholders, and I think that is that's a big challenge. I think that comes when you try to work for CICL. Thirdly, when it comes to educational and vocational training, upon bail and upon release, there is still some access. Efforts are still being made to ensure that the children are permitted to vocational training and education. But within the OH and the special homes, there's very limited linkage. So I was wondering what can be done in that regard. I understand that regular schooling is a huge challenge given the safety concerns and resource crunch, infrastructural issues. But are there any models, are there any plans that can be devised to ensure some way that regular schooling can be ensured? And if not regular schooling, open schooling, how much is it being done, and how much more needs to be done to ensure that it's been that education is not disrupted? And I think lastly and most importantly, as Diksha also pointed out, the lived experiences of people are very important in understanding rehabilitation. So quantitative and qualitative analysis both needs to be there to help us understand how rehabilitation efforts are being taken up, what these children understand by rehabilitation, how stakeholders understand rehabilitation, how ultimately that shapes up. Yeah, I think there are more points, but I think
No, there are many points, Ranu, but there's not much time. So if Nimisha would permit, or you want to quickly, very short. Yeah, okay. Great, that's good.
This is a question actually for Valay, Nainika and Maya. What was the level of difference in the data that you got in as responses from the RTIs? Because are we looking at that fact? Because whatever states I have worked in within departments, I have seen everyone has a different MIS, ways of entering data. Now we have this Mission Vatsalya portal which everyone is struggling with. Are they still, and then there are like 2-3 Supreme Court cases running, including Sampurna Behura, which are demanding data. So are we looking at those interventions of actually standardizing the ways in which the data is being filled in? Because that is for the first place not being done. Second, all of these things that we're talking about over here, the JJB members being selected, the LCPOs, etc., they're being paid for by the department or the ministry, who are just never there in the room when we are talking about these things. And we need to sort of figure out ways of getting them in the rooms.
Yeah, the last part you figure out. That's an easy response. It's not like we did not try. But the response, the nature of it, I would say, was uniformly poor. We had, because how we all file RTIs, you present a table, you ask a certain question. But I think the more important point, as has been made by my colleagues, is that nodal authorities do not have that data. So they transfer it down the line. It could be, we can say, I mean, we also RTI other aspects of the system. So we get this response a lot. But I think that universe of 292 districts, if you check, those out of those 292 districts, we actually collated 272 JJB level responses. 3 states gave us state level response on districts. So you can well imagine that that is the level. So everyone's just shocked and sent it to the last rung. And we've got responses from police stations, we've got responses from homes. Sometimes we think that if a home is responding, actually it's a great thing because they've given us qualitative responses which show that they want help. But of course we cannot capture all of it in this study. So that's my short response. I don't want to take too much time. I think we'll do the last round. Sunil's point on data, and I think all of that, to my mind, has to be backed by financial resources which are just not there. Maya wants to make a quick intervention, so of course we cannot deny that.
Just to say one more thing with that, which is that every single one of these authorities has got a chain of command which is different from the other. So there's no incentive to actually come together because there's going to be no punishment or no consequence from any other authority. The police will only report to the police headquarters. The probation officer only. Nobody is even going to question the magistrate. So it's the power structure as well as the lines of authority that come in the way. Thank you. Sorry.
Data is something that all of us have struggled for a very long time, and that's the note I began on. Today there's a lot of focus on data, for instance, for POXO cases. And to an extent, it's also streamlined. The MIS with respect to POXO is sort of streamlined. But when it comes to children in conflict with law, we haven't been able to do that. And that speaks volumes, about our intentions and willingness to do something. And also volumes about how much we want to maintain oversight over, this particular system. So I think that's where I will end. But considering that we have, I've been in two minds even about saying this today, but I think I should say this today. Because I'm someone who has advocated for the juvenile justice committees and their role as oversight mechanisms. And we are in a situation today that, if you cannot go on the judicial side, because the moment you file something on the judicial side, it is said that, there is a juvenile justice committee that will look into it. But the juvenile justice committee is not doing what it was set out to do. And Justice Lokur is a witness to that. The way they used to meet up annually, there used to be, the departments presenting what has happened, and the judges would comment on that, and then also pass certain directions to be, or points for action to be taken forward. But that has changed completely now. So I think we really need to think through. The more we ask for oversight, it is not about creating more committees. It is actually about putting a process in place. Social audits, we've forgotten. We've mentioned it once in a while, social audit. But nothing has happened on social audit. And now independent evaluation is built into the law, but even on that, nothing has happened. So it's not about creating more and more mechanisms. We just need to have one process streamlined and followed through with consistency.
Sure. Just to add on to that, I think along with the need for streamlining is the need for some sort of empathy building, because at the end of the day, we're only going to reach a point where the stakeholders involved are inclined towards making that effort if they are able to see this demographic as a population of children who are also vulnerable. I think that's where a lot of it gets lost. When we talk about why do children end up in prisons, it's because at the police level, you've got children being diverted straight into a prison system if they're 16, 17 years old and can maybe pass as 18. We've had children we find, we did a study on this a few years ago until this year, last month, we're finding children who visibly look 14, 15 years old, who are in prisons for months on end before we find them. So if we don't talk about a sensitized, sympathetic ecosystem, then the lapses will perpetuate because it is seen that misusing the system is a tool of punishment. That is the only avenue that these stakeholders see as achieving justice. The belief that if you don't put the child in jail for a few months, wo sudhrega kaise? So you start from that point. Then you reach a point where if you've got children in a hugely overfull childcare institution, there is no focus on education because inka kya hi hoga. But to create that empathy amongst every stakeholder where there is at least a desire to achieve these goals, that we're failing at that very fundamental level. So how we achieve that, I think, is the real challenge. How we achieve a state of shift in perception where we can start to see these children as people who deserve the rehabilitation that the law is meant to provide them. And then we start to figure out what are the mechanisms for us to get there. And I think a huge part of that is storytelling and hearing people's lived experiences on both sides. Hearing what the experiences are of the children who end up in the system, and hearing the experiences of the stakeholders who are trying to do something but limited by their circumstances. So hearing each other, I think, is such an important thing, and data at this point is important because it helps us focus on where all we can look. But what I would urge for us now is to go at a more granular, at a deeper level and see what we can get.
With so much being talked about data, my last recommendation to Karnataka High Court JJ committee was that when POCSO cases are being made available online without revealing the name of the child victim, similarly juvenile cases can also be done. So E-Court committee needs to take a step in this regard, and we can have if the JJ committee makes up its mind. So I think that's the starting point of bringing all the data together. With this I end, and I thank you Valay and Maya and everyone here for giving me an opportunity to share. I'll miss my flight if I continue to stay here. Thank you.
No, so I think we'll end there, but for us it is extremely humbling to see so much participation and support from all of you. I think if we can all agree in the next few months that the main ask as a community should be having a data grid which is for children in conflict with the law, no excuses, no shortcuts. We need this public scrutiny in order to have this conversation and this pressure. Otherwise everyone's just getting away scot-free in the name of privacy of children and their best interest, which is just turning it on its head. Thank you again, Geeta, you're off, and thank you, Bharti, thank you, Diksha, so much. And I would, without further ado, request Justice Lokur to please deliver the keynote address, and we can all go and listen to him. Thank you.
Oh boy. That was great, Bharti. It was great, but frightening.
It is.
Yeah. Okay, good evening, everybody. I won't take too long because there's no dinner. Otherwise, I could have continued for another maybe 2 or 3 hours. First, I must say that IJR, Maya, Valay, and their team, they've done an excellent job. Okay. I haven't read through the report. There was not enough time, but I kind of glanced through it, and they've done an excellent job. And this is the kind of report, I think, which should be circulated widely. There are several reasons why I say that it should be circulated widely. And in fact, I told Valay that the Juvenile Justice Committee of the Supreme Court, Justice Nagaratna and Justice Pardiwala, should be given a copy of this report tomorrow, which he says he will. But those who are from outside Delhi, take an appointment with the JJC, whoever it is, in the High Court, and give them a copy. Just let them have a look at the executive summary. They don't have to go through the entire report, maybe just through the executive summary. Some of them have a secretariat, so maybe the secretariat can go through the report. The reason why I am insisting that you should share this with the JJC and with others also, of course, is that there is a sort of a thing that in the newspapers, whenever a juvenile commits a crime, okay, you get big headlines. Juvenile 17-year-old guy commits a murder, does this, does that, and the other. And there's a big thing about it, so then everybody says, oh, kids are behaving like this, they're killing people and, doing all these kind of things. So we must clamp down on them, the laws must be stricter, and, then it goes into a legal sort of a thing. The other side of the picture is crimes committed against children. All right, those are not talked about. Maybe occasionally you will hear something about a POXO case. But I went through the this NCRB report, the most recent one. Now, the IJR report tells us that there are 31,000 odd cases that were filed last year, and action has been taken against 44 children. But the NCRB data tells me that so far as crime against children is concerned, in 2023 it was 1,77,000 as against 40,000 committed by children. So this mindset that is there within the media and which has an impact on society, I think that needs to be changed. And we can start changing that mindset with reference to the report. That is one. The other thing is why I say that this report is very important is because all this work should have actually been done by the NCPCR, should have been done by the SCPCR, should have been done by the Juvenile Justice Committee of the High Court. And here we are, Maya, Vale and their team doing it. Sorry?
There's so many of us.
Yeah, that's what I said, your team. So it just shows, the kind of interest that people have, even the JJC has, or the NCPCR has, in, children, right? So there has to be this very important change in the mindset. I think that's the first thing. And that can come about through awareness and dissemination of information such as the one contained in this report. Now, the third thing that I would like to say immediately is, about implementation of the Juvenile Justice Act that was mentioned by Bharti and others also. What about the implementation of the Juvenile Justice Act? Is that being properly implemented? I don't think so. Actually, some of the things which came out during that discussion, I found them frankly shocking, that children are not being produced. I know from personal experience in certain states, where there are very few children in one district, they are put in another district, and then the people in the other district say that who's going to take the kids to that district? It will take us 2 hours, 3 hours. We'll have to blow up petrol. Nobody is going to reimburse us for the petrol. So forget about it, and they're not produced before the JJB. So you have, very serious issues about implementation. Just a couple of days ago, I was looking at the implementation of the Gram Nyayalaya Act. All right. And what the website told me was that there are something like 300 or 400 something Gram Nyayalayas that have been sanctioned. Out of those 400 odd, maybe just about 300 are actually functional or operational. So really, the implementation of the Gram Nyayalaya Act is there only on paper. Similarly, here with the Juvenile Justice Act, you may have 700 JJBs all over the country, but are they actually operational? That's something which the report tells us the answer is no. Why are they not operational? They're not operational because in 25% of them, you don't have a third member. All right. When you have a principal magistrate, and they're supposed to have a principal magistrate, the principal magistrate doesn't have time to be there for the whole day. So the principal magistrate comes maybe for 2 hours. In some places, Ghaziabad, I think you were mentioning, for 2 hours. In some places, maybe once a week. In some places, maybe twice a week. So when you are told, that the JJB, that the Juvenile Justice Act is functioning properly, because there are 702 juvenile justice boards across the country, whereas there should be 768, that's all right. 702 is a good figure. But that is on paper. They're not actually functioning as such. And the responses that IJR got was from, I think, about 11 of them. Right? 11 of them gave all the responses. So out of 700 plus, if you're getting responses from only 11 of them, how can you say that the Juvenile Justice Act is functioning properly? So implementation is, I think, a very, very important aspect. And somehow or the other, we have to build up public opinion, maybe through the JJCs, maybe through the SCPCRs, to ensure that, the vacancies are filled up. Vacancies in our justice system is a huge problem. In high courts, district courts, you name it, there are vacancies. But I would look at the criminal justice system or the justice delivery system for adults as something completely different from the justice delivery system for children. Unfortunately, what has happened over the years is that, procedures under the CRPC have been injected into the Juvenile Justice Act. So when you go to a magistrate is of course a judicial officer. The magistrate will look at it, from a judicial point of view, is the provision of the CRPC being followed, or now the BNSS, is that being followed or is it not being followed? And then to see whether it is being followed, you need to call a lawyer. And when you need to call a lawyer and there's policemen on the other side, the whole thing becomes, gets into a legal rigmarole. One of the problems, one of the reasons for this is that social workers are not trained. That's the impression that I have, because whenever I've talked to, the principal magistrate here in Delhi and occasionally in some other places, they say that the social workers don't contribute at all. All right. If the principal magistrate is not there and some order has to be passed, they can't grant bail, but if some other order has to be passed, the social workers find it difficult to pass the order. All right. So the contribution of the social worker appears to be, at least from what I've been able to gather, appears to be, minimal. And then you have, of course, attendant problems because of the inactive or non-active participation of social workers. I think we need to educate social workers. The magistrates in the Juvenile Justice Boards are given judicial education, but they are given judicial education on the procedures, not on empathy, which I think you had mentioned. They're not sensitized. And I'm not sure how many of the social workers are actually invited by the judicial academies to participate in these programs, because the social workers are in a majority, right? They are 2 out of 3, and if 2 out of 3 persons in the Juvenile Justice Board are not sensitized, are not trained, are not educated on what they are supposed to do, you're bound to face a problem. So I think we need to get this shift away from BNSS, away from CRPC, away from the adult system, and look at the child system separately. The law for bail under the Juvenile Justice Act is completely different. All right. So why do we continue to follow the same procedures? These are things, which we need to look at, and we need to maybe discuss it with the JJC and say that, listen, look at the whole thing in a different light. Legal aid is something that was mentioned. Now, assuming you continue with this legal aspect where you have the police, principal magistrate, lawyers, this, that, and the other. Legal aid is terrible. All right. I'm not talking about legal aid for children. I'm talking about legal aid generally. I think it's terrible. Recently, this was sometime in February. You may have read about it in the newspapers. There was one minor who had got married to somebody in Bengal, and a POXO case was filed against him. And they got married, they have a child, and the police wanted to put this fellow in jail. And the wife said that, listen, I got married to him voluntarily, there was no inducement or threat or any such thing. And she actually fought for ensuring that her husband does not go to jail. And she lost in the High Court and lost in the District Court. She went eventually to the Supreme Court. Supreme Court gave its judgment in February this year. Justice Oak. He said technically this guy is guilty of an offence under POXO, but the lady is married, they have a child, and the child is about 7 years old, and it doesn't make any sense to send him to jail. So notionally I will just sentence him till the rising of the court, and that was the end of the matter. This lady then gave a statement. Unfortunately she did not give it in court, but she said outside when some reporter must have asked her. She said she had to spend 3 lakhs just to fight this case. Right? Now, if that is the kind of situation that you have, this is not a stray case, let me tell you. I've got, this is a reported judgment, so I can tell you that. But I've heard of similar cases, where people have to spend tons of money just so that, they're not caught in this web of legalese and justice delivery and this, that, and the other. So, legal aid is in a terrible shape. And somehow or the other, we have to do something about it. The IJR talks about legal aid. Anant, you have to do something about it also. So, the whole thing, what I'm trying to present to you is that we have to look at the whole thing, of juvenile justice, implementation of the Act, because it has got various aspects. Look at the whole thing as one unit rather than legal aid, then rehabilitation, then the observation homes and so on. It was mentioned by somebody about some observation home where the windows are very high. Right? Now in Delhi, when I went to the observation home, the windows were at a normal level, but there were bars, and barbed wire and all kinds of things. So I asked them, I said, why have you done this? They said, oh, the kids will break the glass and they'll run away and this, that, and the other. So therefore we are doing this. So the infrastructure or the architecture which was mentioned of these homes is also very important. Okay. But again, somebody has to think about it. Nobody is thinking about it. I know that for legal aid, when the issue had come up before NALSA, I think about maybe 10 years ago, they said, let's have a front office. So many of these legal aid centers in the states have a front office. But for the children in the observation homes, there's absolutely no facility. some of the observation homes I've visited. I had mentioned the other day about Bhopal. Pathetic situation. So again, infrastructure, the architecture of the homes, how do you look after children? These are things which you need to think about. Education, that was mentioned. Education, nutrition, health, all right, again a part of looking after children. Just a few weeks ago, maybe just about a week or 2 weeks ago, there was mention about a district in Maharashtra, Melghat district, where something like 30-40 children died of malnutrition in a period of 6 months. Now, if that is happening in an open society, and that's only about one district, okay, 30-40 kids, what about the observation homes? Are they getting proper nutrition? Are the JJBs looking into it? What about education? Diksha had rung me up a couple of days ago about some children from an observation home being transferred out to a distant place. And my question to her was, are these kids going to a school? She said yes, they're going to some sort of a school. And if they get transferred out somewhere else, that's the end of their education. So these are all a lot of things that we need to look at. Data was discussed, very, very important. I know that there was, kind of resistance to the National Judicial Data Grid when we launched it. When we launched it, I thought it was a big thing, So I told the Chief Justice of India that, can you please launch it? He said, I don't know how to launch it. I said, you just press a button over here and that's it. And very reluctantly, maybe 10 seconds before the launch, he came into the lounge and pressed that button, said a few words and went away. The press at that time created a big noise. Why aren't we invited to this function? We have, in the Supreme Court, you have accreditation. So those who were accredited were invited, those who were not accredited were not invited. They made a big noise. I said, all of you come along. They all came. The lounge was packed with journalists, but not one of them reported it, the next day in the newspapers. So here, fortunately, the IJR has been reported, and that data generation, the NJDG was, I think, if I remember correctly, 2014-15 or something, or maybe even later, but it's taken about 8 or 9 or 10 years to be accepted. But I don't think we can wait that long for data about the juvenile justice system, to be acceptable to people. We have to work on it very, very fast. And Geeta said that, maybe she would like to take it up with the JJC in Karnataka. I think with Karnataka being the Silicon Valley of India, I'm going to get after her to make sure that she talks to the JJB. There are a lot of other things, which we can talk about. One thing which shocked me actually was that kids are not produced within 24 hours. Huh? Yeah. Yeah, she said. Yeah, Geeta. They're not produced within 24 hours. That, on the face of it, is unconstitutional. On the face of it. Now, this is where that dichotomy comes in, between the adult system. I don't think any policeman in this country will have the guts to say that I will not produce an accused person within 24 hours. They may fudge it and say that, listen, we arrested him 6 hours later and all that. But they will make sure that 24-hour thing is followed. Why can't they do it for children? So, but that it should happen, is really extremely painful. That means children don't matter. The Constitution of India doesn't matter for children. can we live with a situation like that? Frankly, I don't think so. And those who are from outside Delhi, please bring it to the notice of the JJCs in your state that this is actually what is happening. Maybe one or two points that I would just like to mention is about you'd mentioned about heinous cases and so on. Now, there's a problem, in the sense that what about rehabilitation? If you have 3,000 cases, how are you going to rehabilitate 3,000 cases? You need to have a child care plan, right? How are you going to implement that? Points was mentioned, which is, she's right. Points is a big thing for the judicial officers. It's very difficult to actually have a balance, Should you dispose of the cases, or should you continue with them so that you can have a child care plan and you can, rehabilitate the child? Now, if you reduce that number from 3,000 to 50, then perhaps you can have, a child care plan, and you can have, rehabilitation and all that. But then you're sacrificing 2,500 kids or 2,900 kids. So it's a very, very difficult balance. And, this had actually come up in Delhi a couple of years ago, where under the JJ Act, the thing has to terminate within 6 months. But the inquiry was going on for 8 months, 10 months, 1 year. And the DCPCR said that, is this permitted by law? I said, no, it's not permitted by law. They moved an application in the Delhi High Court and said that this is what is happening. And the Delhi High Court said, you release them. If I remember correctly, something like 500 or 600 kids were released, because their cases had not been concluded within 6 months. But the problem which you raised, what about the rehabilitation? Okay, obviously no rehabilitation was done, no child care plan was done. So it's a very difficult balance. And that's why, I say that we have to look at the entire JJ system, not in a, segregated manner, but look at it, in a larger context. Everything together. People are doing good work. I mean, all of you are doing excellent work in your field. Fine. But, we should, I think, have, gatherings like this. I was mentioning to Vale that I think one of the important things that, UNICEF helped us with from 2014 to 2018 was to have these regional programs, where 4 states, for example, in the south or in the northeast or something, would meet 1 quarter, and then there would be a national program in Delhi. After 2018, UNICEF said we don't have money. Today also they don't have money. I think the finances of the United Nations have been, cut off. But if you can, persuade your JJB, and let me tell you, the high courts have a lot of money. All right, the budgets are not so good, but they have a lot of money. That's why they can send somebody to pick up Bharti from the airport. Otherwise, they don't have that kind of money for other things. So, if you can persuade them, to start this idea of a regional program, so that there can be a sharing of information, there can be a sharing of knowledge, and the empathy that we are looking for, or the sensitization that we are looking for, will get generated. I think it's a great contribution that was made by UNICEF from 2014 to 2018 to awaken everybody that children also exist in this country, and children also have rights. I think if we can restart that process, I'm sure it will make a difference. So thank you very much, and Maya, it's really wonderful. You guys have done a terrific job. Vale, you and your team, excellent job. Yeah.
Hello everyone. As the evening comes to a close, I would like to express my gratitude to everybody that's made this event a success. First and foremost, our deepest gratitude to Justice Madan Lokur. Thank you, sir, for being here today and for your unwavering support. A huge thank you to our panelists, Bharti Ali, Disha Gujral, and Geeta Sajan Shetty for their invaluable insights, this meaningful discussion, and for their work for young people whose futures deserve dignity, patience, and a system that does not give up on them. Our sincere thanks to our data partners at How India Lives for tirelessly working alongside us. We are immensely grateful to all our partner organizations who have stood by us throughout. I would also like to thank the subject experts for helping us make this study more comprehensible. Thanks also to our donors for standing rock solid behind us, and we hope they continue to do so in the future. Most importantly, a very special thank you to Maya and Valay for their able guidance and their leadership, to Nainika for effortlessly executing this research study. And I would also like to thank some of my colleagues and former colleagues whose vital contribution ensured that this report saw the light of day. Arshi, Neda, Bharat, Dipul, and Krishna. Our intern, Rajnandini, as well as Ajayji for their support in ensuring that this event ran smoothly. Lastly, I would like to thank all of you. Thank you for making this event truly special. We hope you read our report and circulate it widely and use it to augment your work. Also, while you head out, there's a study, which is a pilot study we've done on the budgets for justice. Please feel free to pick that up as well. Thank you so much.
We always never forget to thank our funders who make this work happen. So I'd like to formally thank our funders, and also Madhusudan Srinivas, who helped us with the media outreach, as well as Prabhat Kumar, Anant, and so many others who guided us through the whole report's development. Thank you.